Whereas for the purposes of considering the request for indication of provisional measures, the court needs only to decide whether the rights claimed by the applicant on merits and for which it is seeking protection are plausible. The standard of plausibility was reiterated in Belgium and Senegal, where the court observed that, and I quote, "Whereas at this stage of the proceedings, the court does not need to establish definitely the existence of the rights claimed by Belgium, or to consider Belgium's capacity to assert such rights before the court, and whereas the rights asserted by Belgium, being grounded in a possible termination of the Convention Against Torture, therefore appear to be plausible." There have been 3 instances in which this court has entertained applications arising from allegations of breach of Article 36 of the Vienna Convention. The case of Paraguay and United States of America, which is the first of the cases relating to violation of the Vienna Convention. The request of Paraguay for indication of provisional measures was decided by this court on 9th April 1998. Paraguay instituted proceedings against the United States of America on 3rd April 1998 on allegations of violations of the Vienna Convention and sought indication of provisional measures by way of an order by court that the government of the United States take measures necessary to ensure that the Paraguayan national in relation to whom proceedings were brought be not executed. This court enunciated the standards by which such a request for provisional measures would be decided. It observed that, and I quote, "On a request for the indication of provisional measures, the court need not, before deciding whether or not to indicate them, finally satisfy itself that it has jurisdiction on the merits of the case. But whereas it may not indicate them unless the provisions invoked by the applicant appear prima facie to afford a basis on which the jurisdiction of the court might be founded." Unquote. This court further indicated that the purpose of the power to indicate provisional measures is, and I quote again, "to preserve the respective rights of the parties pending its decision, and presupposes that irreparable prejudice shall not be caused to rights which are the subject of a dispute in judicial proceedings. Whereas it follows that the court must be concerned to preserve by such measures the rights which may subsequently be adjudged by the court to belong either to the applicant or to the respondent, and whereas such measures are only justified if there is urgency." Unquote. The court found that the circumstances of the case required it to indicate, as a matter of urgency, provisional measures as provided for by Article 41 of its statute. The second case relating to violation of the Vienna Convention was brought by Germany against the United States of America, known and cited as the Legrand case. On 3rd March 1999, this court indicated provisional measures pursuant to an application filed by Germany. This court reiterated the principle that generally interim measures would not be ordered in the absence of, and I quote, "irreparable prejudice to the rights which are the subject of the dispute," end of quote. The court held that the execution of the German national, Mr. Walter Legrand, and I quote again, "would cause irreparable harm to the rights claimed by Germany in this particular case," end of quote. This court also observed that, and I quote again, "measures indicated by the court for a stay of execution would necessarily be provisional in nature and would not in any way prejudge findings that the court might make on the merits," end of quote. The court indicated that the United States of America should take all measures to ensure that Mr. Walter Legrand is not executed pending the final decision in the proceedings before the court. In the third case relating to violation of the Vienna Convention was brought by Mexico against the United States of America, known as the Avena case. Mexico sought relief in relation to 54 Mexican nationals who were on death row in the United States and in respect of whom Mexico asserted that they were arrested, detained, tried, convicted, and sentenced to death by competent authorities of the United States in proceedings which did not comply with Article 36 of the Vienna Convention. The relief that was sought by Mexico was in the nature of restitutio in integrum. The application was filed by Mexico on 9th of January 2003 for indication of provisional measures, and the apprehension on which these measures were sought was that the three nationals could be executed within the next 6 months, and many others before the end of 2003, and one of them by 14th February 2003. This court said that it, and now I quote, must be concerned to preserve the rights which may subsequently be adjudged by the court to belong either to the applicant or to the respondent, without being obliged at this stage of the proceedings to rule on those rights. The court added that its power to indicate provisional measures is intended, and I quote again, to preserve the rights, respective rights of the parties pending its decision, and presupposes that irreparable prejudice shall not be caused to rights which are the subject of a dispute in judicial proceedings, end of quote, and that provisional measures are indicated, and I quote, pending the final decision of the court on the merits of the case, and are therefore only justified if there is urgency in the sense that the action prejudicial to the rights of either party is likely to be taken before the final decision is given. The court cited its earlier order in Finland and Denmark. This court reiterated that for indication of provisional measures, the court need not satisfy itself before deciding whether to indicate such measures, that it had jurisdiction on the merits of the case. The test applied by the court was the existence of a prima facie basis on which the jurisdiction might be founded. The court noted that the position of both parties and observed that whereas there is thus a dispute between the parties concerning the rights of Mexico and of its nationals regarding the remedies that must be provided in the event of a failure by United States to comply with its obligations under Article 36, paragraph 1 of the Vienna Convention, whereas that dispute belongs to the merits and cannot be settled at this stage of the proceedings. End of quote. The court reiterated, and I quote again, whereas the court, when considering the request for indication of provisional measures, must be concerned to preserve the rights which may subsequently be adjudged by the court to belong either to the applicant or to the respondent, without being obliged at this stage of the proceedings to rule on those rights. End of quote. Rejecting the suggestion that there was no urgency as contended for by the United States,